Greetings, this is Pastor Mike in Southern Oregon. I'm here to make a video about DUI checkpoints. And we're going to, it's been a while since we made a video, so we're having to assign new numbers now. We're going to start over for 2020. The number here will be 2020 V for video -001. We just decided to start over with number 1, 2, 3, 4 for each year. And we're going to begin by reading the disclaimer the way I usually do. I'll do that right now. Before I start that, I will say what today's date is. Today is the January 19th, 2020. And like I said, the subject will be DUI or DUI checkpoints. All right. The information provided herein is for educational, truth, and knowledge purposes only. No specific course of action is directed except the advancement of knowledge and truth. I now state and clearly declare that I am addressing the subject matter set forth herein as a pastor of God in my religious and ecclesiastical capacity and office, and that I am exercising my official function to keep religious believers informed of their various rights, freedoms, and liberty under God and relative to their awareness and understanding of the various laws of man. Therefore, I hereby declare, claim, and assert any and all religious protections of whatsoever nature and kind, including protection from discrimination on the basis of religion, available under the inherent, inalienable, primary, and subordinate rights and laws. The Remnant Church in Southern Oregon, Mike Benjamin's Jr., pastor, that's me, in both his personal and ecclesiastical capacities, including his subordinates and personnel, individually and jointly disclaim any and all liability and or responsibility for any damages sustained or suffered by the readers, viewers, or other entities in the implementation of the teachings set forth in this video. The material is provided as a research study project for learning purposes only, and any implementation and or applications contrary to my various cautionary statements, which I make from time to time, are undertaken at the sole risk and peril of the readers, viewers, or entities. No statement is made or implied as to the ultimate outcome resulting from such implementations and or applications. Okay. What I'm going to do here, in the past, what I have been doing is I have been making a very structured video with a lot of detailed notes. I'm not going to do that this time. This is going to be more informal. My cameraman can ask questions. That's my son. He's running the camera. We're going to try to work through this subject matter so that you get an idea of what to do at a DUI checkpoint. Now, in the past, over the years, they've called it different things. In some places, they call it DWI, which is driving while intoxicated. In other places, they call it DUI, which is driving under the influence. And in other places, they call it DUII, which is driving under the influence of intoxicants. So you may hear different ways of expressing it. In this particular case, they're calling it DUI. All right, now, just to give you a little background, I'm a pastor here in Southern Oregon. I write treatises on Facebook. I've made videos in the past. I address legal and non-legal, religious and non-religious, and other related issues which are of concern. Now, while I'm a pastor, and I usually do as if I'm talking to believers, this is not just for believers, it's for non-believers as well. You might say, oh, he's a pastor, I'm just going to walk away from the video and I'm not going to watch any further because he's just going to talk about God and he's just going to talk about stuff that I don't believe in. I would tell you this: don't do that. You want to listen to what I got to say. And if I say something religious that doesn't apply to you, well, just skim over it. Don't worry about it. Stick around, because I don't talk only about religion. I don't talk only about the Bible. I talk about a lot of other things that you can use. Therefore, it is worth your trouble to spend a little time from your busy schedule, and rearrange your priorities so that you can know what to do in certain situations. Okay, it's always based upon your own judgment. It's always based upon your own understanding of the issues. If you don't think that I've done my homework and you think that I'm wrong on a case analysis or a case brief or whatever, you can always go read the case yourself. We live in the information age. You can just go to Google and Google something and find out somewhat, what that's all about. So we live in the information age. You can find these things out. My background, like I said, but I didn't go deep into it. I started out in the military police in the U.S. Army. And after the military police, I went to college, and then I also went into the civilian policing. So I've got policing in my background. I can tell you things about the issues like these DUI checkpoints. Now, I've never been involved in a DUI checkpoint. They weren't doing them when I was a cop. But anyway, the point is, I understand the way cops generally think. And that may give you a perspective that maybe a lawyer who's talking to you about the legal issues wouldn't exactly know, because there are some lawyers that have also been police officers, and they would know because then they've done both. But anyway, the point is, I can give you some perspectives on this that you might not get any other way. So that's what we're going to do. We're going to jump in and we're going to take a look at things. Also, I wanted to tell you that in, let's see, I've been having some computer issues and I keep trying to do things. This all happened since Windows 7. There's no more support for Windows 7, so I had to go to Windows 10, and the computer keeps telling me it's not responding. And I understand that, because sometimes people ask me to do things and I don't respond either. But anyway, the point is, that's why I'm reading off of paperwork rather than reading off the screen, because I've been having some trouble here with trying to make the computer do what I want. What I want to do here is talk about these videos that are already on here. One video is on DUI sobriety checkpoints, is done by Michigan Attorney at Law Steve Lehto, Lehto. It's worth watching. It's already on my Facebook sites. You can scroll down to it and give it a look. The other one is done, he's from Michigan, by the way, which is where that's where these DUI checkpoints started, over in Michigan. The other attorney is in Oklahoma. His name is Jay Ramey, and he also has done a video on, he calls them DUI roadblocks, same thing, and he talks about it as well. You can scroll down to his video and take a look. So we're just going to jump in and get into it here. I had previously written, this was on the Steve Lehto DUI sobriety checkpoint video, and I'll read to you what I wrote here. I wrote, this is a video where Michigan Attorney at Law Steve Lehto is discussing DUI sobriety checkpoints. He addresses when the U.S. Supreme Court ruled that such checkpoints do not violate the Fourth Amendment, okay, but may still violate the state constitutional provision. So you have to deal with both of those things. Various states, including here in Oregon, do not at present operate such DUI checkpoints. There are about 10 states that either because it violates the state constitution, even though the federal government said it is not a violation of the Fourth Amendment to run these checkpoints, that doesn't mean it's not in violation of the state constitution, and that's why maybe they don't do it in these various states. There are like 10 states that don't run these checkpoints. Oregon is one of them here where I am. And also, as I understand it, Hawaii doesn't run these checkpoints either. They don't have a provision in their constitution which prevents it. They just decided not to run the checkpoints there in Hawaii, which I applaud them for that. It's Alaska. Oh, I thought it was Hawaii. No, it's Alaska. Okay. It's Alaska or Hawaii. So if you're in one of those states and you run into a checkpoint, we might have been wrong about where it was. But anyway, let's go on. The reasoning the U.S. Supreme Court, which was Justice Rehnquist, was the one who wrote the decision in that case, was essentially that drunk driving was a problem that the states had a right to address, and that a sobriety checkpoint only involved a brief intrusion of the freedom of motorists. So they're saying, drunk driving is a problem. The state, in the interest of its citizens, has the right to do something about the drunk driving problem, and they said that the intrusion upon the freedom and liberty of the motorist was minor. It was just a small thing. And therefore they said that it passed the reasonableness standard, which they talked about that in the case as a major point. They says, well, it's reasonable. So therefore we're going to go ahead and say it can be done. That's what happened at the United States Supreme Court level. This is the idea that they had. Thus, the court held that it was reasonable to briefly inconvenience motorists in order to interdict drunk driving. Then you have the argument of neutral indicia, which has come up in these DUI checkpoint issues. Neutral indicia meaning they're funneling everybody through this checkpoint. They're not zeroing in on anybody in particular, or any person or persons. They're just funneling everybody through. They call that neutral indicia, meaning that they were stopping everyone, not focusing on any person in particular, has also been argued as a reason why these DUI checkpoints are justified. I personally do not agree with the High Court and maintain that it is a violation of the Fourth Amendment. The video explains much more. I'm talking here about the video of Steve Lito. So give it a look and listen. If you haven't done that, go ahead and do that. Now I want to bring up something to your attention. One last thought. When I was in law enforcement, we had no problem impacting drunk driving without DUI checkpoints. That had been done for years. It isn't like the states weren't going after drunk driving. They've been going after drunk drivers for a long time. I have. And it was actually kind of a pet peeve for a lot of police officers. It says, oh yeah, we got to go after these drunk drivers. And if you were on swing shift and on graveyard shift, when people got out of the bars and whatnot, we spent quite a few hours going after drunk drivers during that time of day. That was one of the things we did a lot during graveyard shift. Now this Michigan case, where this all started, and apparently the way this works is, in Michigan they decided one day that just having police officers go after drunk drivers the regular way, they wanted to start these drunk driving checkpoints. And a case was filed in the Michigan trial court, and that case was the Michigan Department of State Police versus Cites. That's the case that finally ended up in the Supreme Court. I'm going to explain in a minute. When it got to the Supreme Court, the case site was 496 U.S. 444. That was in 1990. All right, let me go to the board here real quick. What originally happened was they started these checkpoints, and they filed suit in a Michigan trial court at the state level. The trial court said that these checkpoints violated the federal constitution and the state constitution. It was then appealed up to the appellate court level, to the Michigan appellate court. The appellate court affirmed the lower court and said, yes, it violates the United States Constitution and the state constitution. It was then appealed up to the Supreme Court of the state. The state Supreme Court there refused to hear it, which can mean, let me explain a little bit about that, which can mean that they agreed with the lower courts and that they said, well, there's nothing for us to hear. They ruled correctly in the trial and appellate court, so we're not going to hear it. Sometimes they call that affirmed without comment. However, just because they don't hear it doesn't mean necessarily that they agree. They could not hear the case for other reasons. Maybe they had too many cases. Maybe there was all kinds of reasons that sometimes the cases are not heard. So don't make the mistake of thinking that just because the Supreme Court doesn't hear the case that they agree with what the lower courts did. That's not necessarily true. Then it was appealed straight up to the Supreme Court of the United States, where what the trial court, state trial court and state appellate court, they reversed what they said. They said, no, it doesn't violate the Fourth Amendment. And I told you what the reasoning was there. They said it doesn't violate the Fourth Amendment. So they said, we rule then that it's not a violation of the Fourth Amendment for the reasons that we said. Okay, the problem is that the appellate court in the state of Michigan had already said it was a violation of the state constitution. Therefore, it held. Even though the Supreme Court said it's not a violation of the Fourth Amendment, but it was still a violation of the Michigan state constitution. Therefore, they don't run the checkpoints there because that stayed. And that's basically where it is now. There's another interesting point that needs to be addressed, and I'll do that right now. At the state level, when they said that it was a violation of the U.S. and state constitution, they said that basically they said this: the checkpoints are a substantial, they use the word substantial, it's a substantial intrusion into the rights and privacy of the people. That's what they said. But when it went to the Supreme Court, to the U.S. Supreme Court, they said something different. They said, no, it is only a slight, and they used that word. Instead of saying it was substantial, they said, no, it's only a slight intrusion into the privacy and rights of the motorists and the people. Therefore, in the interest of the state having a what they were calling a legitimate and grave interest in the interdiction of drunk driving, we believed it to be reasonable to stop these people at these checkpoints for a short time. That's basically what it was. And so then it went to the reasonable standard, and I'll talk about that in a minute when we read the Fourth Amendment. Okay, so that's enough of the board then. Let's go back to where we were before. All right. Now I'll read this case cite again so you know. It's cited as Michigan Department of State Police versus Sitz, S-I-T-Z, 496 U.S. 444, 1990. Now, the question in the minds of many people is this: are these DUI checkpoints constitutional? Let's take a look. Let's take a look at that issue. I realize that the Supreme Court has said it's not a violation of the Fourth Amendment, therefore, ipso facto, they're saying it's constitutional to run those checkpoints. I have never felt that way about them. From the very first time that I heard about them, I was convinced that this was absolutely not constitutional and it was not lawful for them to do that. But when the highest court in the land says it's not a violation, well, you're sort of stuck with it, you see. Kind of. All right, let's read the Fourth Amendment. Let's take a look. What does the Fourth Amendment actually say? It says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizures, shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Now, under the law, what is going on here is that when they stop you they funnel you into these DUI checkpoints. They are seizing you. It says here in the Fourth Amendment, unreasonable search and seizures, okay? Under the law, that is a seizure of your freedom and liberty. So if you're trying to figure out, well, how does this fit into the Fourth Amendment? They're talking about searches and seizures. Okay, well, it's a seizure of your liberty. This is not something you get to choose. You have no choice in the matter. You're funneled in and you've got to go through this checkpoint. Okay, so they're seizing your liberty. It is an unlawful seizure. And of course it says, the right of the people to be secure in their persons. It says persons, houses, papers, and effects. Well, zero in on persons. The right of the people to be secure in their persons is what you have to zero in on. You want to be secure in your person against unreasonable searches and seizures. Now zero in on the word unreasonable. This is where the Supreme Court put its pry bar, and they started prying on reasonableness and says, is this thing, that's what actually decided the case. They said that it was reasonable to funnel Americans funnel them in without choice, funnel them into a checkpoint against their will and choice, and they said briefly, they all called it, that they all kind of zeroed in on the idea that it didn't take very long. It's in one place it says, well, it took as little as 25 seconds, which I have my doubts about that. I've watched on YouTube, I don't know if you have, but I've watched the videos where people have recorded when they went through one of these checkpoints, and I can guarantee you most of those did not last for 25 seconds. But anyway, if everything goes perfectly and the police are not suspicious, and let's say you answer the questions just right so that the police don't give you a hard time, you might get through there in 25 seconds. I don't know. I doubt it. But anyway, let's say you can do that. Does that make it reasonable? Does that make it legal? Those are the questions you have to ask yourself, you see. It really, my son brought this up, and I have to agree with him. He says it's not a question of whether it lasts 25 seconds. It's a question of whether it was legal or not legal. If it's illegal, it doesn't matter if it lasts 1 second. The focus of our focus should be on the legality issue, not the time, not the amount of inconvenience. Somebody's putting off fireworks out there, sounds like.
Sounds like it.
Yeah.
I have a question,
Okay.
if you don't mind.
Yeah, question.
Is this the first time that you're aware of that the court said that a detention without some sort of probable cause or reasonable suspicion was reasonable?
No, I don't think it is the first time.
It's not the first time.
I think they've addressed that issue before. But anyway, the point is, a short detention, if reasonable and necessary, if you can articulate as a police officer that it's necessary. For instance, if it's looking suspicious, as you know, there are standards like reasonable suspicion and probable cause. But anyway, if you can articulate a reasonable suspicion, you're probably going to be able to say, yeah, I detained him for a short while to straighten that out, for the protection of the police, protection of the public, and all that. These kind of things in a society, I believe, I'm not even going to argue against that. It isn't necessary. It's necessary to check people out sometimes. So anyway, that's the Fourth Amendment. Now, what we have to try to process, we have to take this information. We read the law, and that's actually, by the way, that is what the practice of law is. The practice of law is to take the law and apply it to the set of facts. So we've just read the law. We've just read what the Fourth Amendment says. And we have to figure out, well, if we look at the fact pattern, how did these facts come together? Is it proper to apply the Fourth Amendment to those facts? That's what you have to figure out. But anyway, it doesn't stop there. We also have to check out the Fifth Amendment. Now, I'm only going to read part of the Fifth Amendment that applies, not the whole Fifth Amendment. And that is, it sets forth, no person shall be compelled in any criminal case to be a witness against himself. And just because it says himself doesn't mean it doesn't apply to women. It's also against herself. Nor be deprived of life, liberty, or property without due process of law. Now, the words there are important. You're being compelled. You don't have a choice. You're funneled into a DUI checkpoint. You are definitely being compelled. In any criminal case, they're not funneling you into that checkpoint to give you cupcakes. They're there to find out if you are a drunk driver or if you are under the influence of drugs, and if you then are violating the criminal statutes of the state. That's what they're there for. So it is a criminal case. And then it says you can't be compelled to be a witness against yourself or deprived of life, and here's the word, liberty, or property without due process of law. They're depriving you of your liberty by seizing your freedom and liberty for whatever time it takes. And I can tell you that this 25 seconds thing isn't for real. First of all, we should really, well, let's talk about that for a minute. First of all, if you run in one of these checkpoints, you're going to have cars start backing up. So depending on how many cars are backed, if you're lucky, you get there at a time when there's only 2 cars, well, no problem, One car goes through and then you go through. It's not going to take a long time. But if you're way back there at the end of the line, you aren't being deprived of your liberty for 25 seconds. You got to add to that, how long do you have to stand in line so you can be processed through the checkpoint? That is what you have to think about. That is what you have to add to the time that this thing about, it's a brief intrusion. It's not a big inconvenience. Yes, it could be. It could be a big inconvenience. Then when you finally get up to the checkpoint, let's say that you're not very cooperative and you're not answering the questions that the police asked the way they would like you to answer them. In other words, you're not witnessing against yourself sufficiently enough to satisfy the police. Okay, well, then they're going to say to you, probably, they're going to say, okay, well, you're in this line of cars here. Why don't you pull your car over there and we'll get to you over there, you see. Well, now we've got to add to the 25 seconds, because how long are you going to be over there? And if they decide to bring sniff dogs around and say, well, maybe we ought to get a dog out here and sniff up your car, Well, we're going to talk about that stuff later. But anyway, and then, I hate to say this because I was in law enforcement myself, but chances are when they bring the dog out, they're going to say, he cued on drugs, you see. And how did he do that? I don't know. He twitched his nose just right and he cued on drugs. So now we're going to have probable cause to search your vehicle, or we're going to have probable cause to do whatever until they come up with something, you see. So you could get in trouble with the problem of contempt of cop. And if you upset the police, sometimes your detention is going to be longer than 25 seconds. All right. Now, I want to talk about, I'm going to set this paper down for a second and talk to you about what it's like to be a cop. When I was in the police department, and I went through the training, I've been through more than one police academy, and I went through all the training, and here's what I found out. All right, you go to the police academy and they say, here's what you do when you do this, here's what if this happens, you do that, this is how you talk to the citizens, this is how what I was told was this: you have to be firm but businesslike. Okay, you have to be professional, firm, and businesslike. You should do the same thing, by the way. You should be professional, firm, and businesslike. Now, here's what happens when you're a cop for a little while. Cops see the worst of life. They don't see little old ladies bringing cakes around all day long and giving you free cakes so that you can have a nice cheesecake or some other kind of cake. What you see as a cop is a lot of things that go wrong. You see some really ugly things. I've seen some really ugly things. I am fully aware of what people are capable of. I'm fully aware of what cops are capable of. I'm fully aware of what a lot of people are capable of. As some attorneys have said in the past, they said there's good cops, there's bad cops. There's good people, there's bad people. There's good lawyers, there's bad lawyers. I think across the board you got that dynamic working for you. But anyway, over time, you get a view of society which is not the healthiest of views, because you're looking at the dark side of society. Now, here's what happens. And I already told you that drunk driving is a pet peeve of police officers. Here's what happens. Once you've been exposed to that for a while, and you begin to believe that if you're not out there on the street with your gun and badge, why, the sky might fall. The dam might break. The whole thing may crumble. The only thing standing between you and disaster is you and your badge. And therefore, I've got to save society. I've got to, that's what I stand between the fall of society and a society that still functions. And this is in the heads of a lot of cops. Now, if you talk to people, if you talk to the cops at DUI checkpoints, don't be surprised if they say, look, I'm just trying to make it safe for everybody by getting these drunk drivers off the street. You see, cops don't sit around and say, I'm going to do a legal analysis of whether or not this checkpoint is okay to do. You know, they don't do that. They're told they can do this. It's their job. And they said, now you go to that checkpoint, you be a cop at the checkpoint, and you do your job because you're saving society. I believe some of that myself. You see, I was a cop long enough that I thought, you know, this has got to be done, or why society will just fail. It'll just fail. And you know, there'll be dead bodies in the street, and you know, all kinds of disasters and heinous and vile things are going to happen. I'm standing in between that happening and that not happening. So before you get too hard on these police officers, you say, well, this guy's just a jerk. You know, here I am going about my business, you know, going down the road, and here they funnel me into this silly checkpoint and mess up my day and seize me of my liberty and, you know, ask me a bunch of questions that I don't want to be asked, and basically inconveniencing me for what? What don't these guys have? Don't you have criminals to go after? You're out here bothering me, who the worst thing I did all day was drink a Coke. You know, but anyway, the point is, I want you to understand what it's like to be a cop. You see, what it's like, what's in their heads. My son pointed out to me, he says, I know cops, and they're not out there trying to tear society down or do bad things to people. That's not in their heads. They're going to revert back to their training. They think they're doing good, and they've been trained to do a certain thing. Just like I said in the academy, they say, if this happens, you do this. If that happens, you do that. If somebody says this to you, you say that back to them. You see, they're just going back to their training, and a lot of them, now I want to be careful here, I don't want to say the wrong thing. A lot of them don't know enough law to be able to analyze whether a checkpoint is legal or not legal. They don't know enough law. Now, I'm not saying that all cops are like that. There are cops out there that know quite a bit. My rule is never underestimate other people. It's not a good policy. But a lot of cops, they don't know enough law. You start arguing with them, which is, by the way, which is something you should not do. Start arguing legalities with them. That's probably not a good idea, because first of all, he doesn't know enough to be able to keep up with that anyway, you see. And you say, well, this isn't even constitutional. But heck, he's been told it is constitutional. He's been told that the Supreme Court said it's not a violation of the Fourth Amendment, if he even knows that. And that Judge Rehnquist, back in the day, was involved in the case. He might not even know that. But anyway, that's all he needs to know to be able to be out there doing it. So don't argue legalities with him. That's not what you want to do.
If I might like to add something. Some of the police officers' fears that if they weren't out on the street there would be problems is true. It is a founded concern. That being said, we have to be careful with this giving them too much free license to do unlawful things based on that
Correct.
idea.
Yeah, I didn't want to apply that we should put up with illegality.
No.
Yeah. I'm just wanting you to understand what's in the mind of a cop. Mm-hmm. You see, that's important. We have to have some understanding before we get all high and mighty and say this is an absolute unreasonable intrusion into my life, which maybe legally it is, but anyway, be understanding. This is another human being trying to do a job. And he or she thinks, I've got to do this job. So we need to be somewhat understanding of this. All right, let's go on. Let's reflect. I wrote a little narrative here about what happens at a DUI checkpoint. Now, it starts off this way. I wrote, let's reflect. At a DUI checkpoint, a person is being funneled into a checkpoint operated by the police. Okay? They are government official. It's a government official or officials, more than one, and this is being done against your will, against his or her will, under the color of law. By color of law, I mean it has the appearance of being legal under the color of law, so that the police can investigate whether or not a person has been drinking alcoholic beverages or is under the influence of other intoxicating substances like drugs. This is part of a detain, investigate, and allowable search. I wrote allowable because not all searches are allowable. We're going to get into that. A search effort to look into criminal activity. To wit, what kind of criminal activities? You'd say, to wit, what criminal activity? Well, the criminal activity of driving while intoxicated, and that is a criminal offense. Okay, that's what they're there for. Don't get confused about what you're there for. The thing that you want to do, and Jay Ramey, the attorney that made one of these videos, he rightly says, don't get into a conversation with these people like they're your best friend. They are not your best friends. They're there to find drunk drivers. All right? Your objective is to get in and out of there as fast as you can and get down the road. That's your objective. Hopefully unscathed. Moreover, in order to carry out this use of police powers to achieve that effort of finding drunk drivers, a person's liberty is being seized. It's called being detained for a short or longer period of time, and they are being subjected to a detaining of their freedom until allowed to proceed further. Okay, the question, of course, is, when am I free to leave? I'm funneled into this thing, and I want to get out of here as fast as possible. When am I free to leave? I should really kick in one other point here before I forget about it. It's against the law now that if you are being funneled into this checkpoint, some people say, a DUI checkpoint. And they may not be drunk. They may just end up being funneled into this checkpoint. And they will say, I'm going to turn around and go a different way, or I'm going to go the other way. Well, the police go after you now for that. So that is an offense in and of itself. And they will go after you. Okay, so it isn't like you can do that. You can change your mind. Now, they would probably allege that the reason you turned around and left is because you're a drunk driver and you're trying to get away. But that isn't the only reason a person would turn around. Let's think that one through. Is that the only reason, if you see a checkpoint like that you would turn around and go a different way? Is because you're a drunk driver, and you say, well, heck, the last thing a drunk driver wants is to go through a DUI checkpoint, That's not the only reason. And I think that has to be acknowledged. All right? Note, this is initially a warrantless practice and procedure. In other words, there's no warrant in place to do this. Presumably based upon exigent circumstances. Exigent circumstances is a phrase that police officers are taught, and also, of course, legal professionals know the phrase, which means that the circumstances are such that it would not be efficient to have to get a warrant every time. The reason it's exigent is because it's a movable vehicle. And if there is evidence of crime or contraband in the car, it's going to go away because it's on wheels, and gone goes your case. That's why it's exigent circumstances. That's why some searches don't require a search warrant. Okay, in that it involves a moving vehicle, the consequence of which risks the loss of evidence of crime. During the checkpoint detainment of freedom and liberty, the person driving, and perhaps others, if there's other people in the car, they're going to be under the scrutiny of the police as well, okay, are subjected to plain view inspection as well as other intrusions based upon human senses such as smell. Now, let's talk about plain view for a minute, okay? There's a plain view doctrine which says that if something is in plain view, the police can go after it. It's in plain view. Let's say that you've got a half-open bottle of whiskey on the back seat. All right? The police, you go through the checkpoint, they're out there with their flashlights shining it all over. That's what we do, we take our flashlights out and we go, we do like this. Oh yeah, let me have a look at that here. Aha! A bottle of whiskey, half used. Now, that's in plain view. They can go after that. They need no search warrant. It's in plain view. They can seize it and use it as evidence. All right. The thing is, think that through for a minute. I'll ask my cameraman. If you are a cop and you see a half empty or half full bottle of whiskey in the back seat, does that necessarily mean that the people were drinking it in the car?
No. However,
No.
open container, whether drinking or not, is a crime.
Violates the open container law.
Yep.
But does that mean they were drinking?
No, they may not have been.
Yeah. They may be just moving a half-full bottle of whiskey from one place to another.
Correct.
So, what I'm saying that for is, and he rightly says, the open container itself is an offense. However, does that mean that the person was drinking? No. And I think that we tend, as people, we tend to make various assumptions that are not well-founded. And we shouldn't do that. If you see, I'll give you an example. If you see a man and a woman walking together, and they got a little child, let's say it's a little girl, and they got a little child with them, and they're taking the child along with them, and they're walking. The first thing that you would assume is that those are the parents of that child, because that's what it looks like. You see a man and a woman and a child. Oh, that must be the mother and father of that child, and they're probably married, or at least boyfriend or girlfriend, or living together, or something like that. You see, those are assumptions. There's a situation where you can see something like that, and the man may not be the father of the child at all, and may not even be involved with the woman at all. He's just walking with them. You see, we need to report, and then when somebody asked you about, what did you see? Well, I saw a man and woman and their kid walking down the street. No, you didn't. You see, you saw a man and woman and a child walking down the street. That's what you saw. And that's what you should say. But we tend to confabulate what things mean and what we think we saw. And we have to be careful of that. All right.
We're going to have to stop for a minute so I can switch SD cards. We're almost out of time on this one.
Okay. Go ahead and stop this and we'll start it back up. Okay, we're back. We had a little camera glitch. We had to switch over to a different data disk, but that's done. So we left off with plain view. So anything in plain view, you know, is fair game. All right, now, and I wrote here, as well as other intrusions based upon human senses such as smell. Why would I bring that up? Because when you roll up to the DUI checkpoint, they're going to want you to roll your window down. Unless you're on a motorcycle, then this is not an issue. But if you're in a vehicle, they're going to want you to roll your window down. The reason for that is so that to see if they can smell alcohol, marijuana, whatever. They're going to use plain view. They're going to use smell. If they smell alcohol, well, that's fair game. They smell alcohol. You know, gives them a reason to want to go through the car and search it. And can be ordered. You can be ordered to exit the vehicle, probably based on a Terry versus Ohio style stop and frisk search. Okay, Terry versus Ohio is a case that started all this stop and frisk business, and that was let me check real fast. Terry versus Ohio was 1968. Michigan Department of State Police versus Sites was 1990, and then there's also Brown versus Texas. We're going to talk about that. That's 1979. But anyway, the point is this stop and frisk. See, they need no search warrant to do that. That's because the public or the officer may feel they're in danger. If they think you have a weapon, they're going to pat you down, and frisk you to see if you have a weapon. They're going to have you get out of the car to do that. They can do that. Two things I would tell you. If they order you to lower your window, lower it. If they order you to get out of the car, get out of the car. Don't argue with them. Don't get into long conversations with them. You can ask them this. You can say, is that an order? Are you ordering me to get out of the car? Yes. Okay. Are you ordering me to lower the window? Yes. You can ask that. If he says yes, then you lower the window. If you don't lower the window, they could break it out. If you don't get out of the car, they'll drag you out of the car. So what I'm telling you is it's in your best interest. You can make decisions for yourself when you get up to these checkpoints if you go through one. And say, I'm not going to lower my window. Well, okay, if you want to buy a new window, you can go that route. Or you can say, I'm not getting out of the car if he tells me to get out of the car. Not a good idea. I've seen people drug through the window hair first, by police officers, and that's not a nice way to get out of the car, you see. You do not want to go down that road. All right, so go ahead and get out of the car. Go ahead and let them frisk you because that's for everybody's safety. All right, now, let's go on here. They can and usually are subjected to police questions such as, how much have you had to drink? Where are you coming from? Where are you going? Etc. In which you are being asked to be a witness against yourself. Remember the Fifth Amendment? You don't have to be a witness against yourself. Yeah.
I have a question. If they pull you out of the car and they want to pat you down, should you object to such search? Not resist.
Should you object?
Not resist.
No, you should not resist. If you want to say, now we're going to get into that later. That's on one of these pieces of paper I got here. If you want to say, I do not consent to searches, it doesn't mean there's not going to be a search. It means that you're not consenting to the search. You can say that. You can say, I do not consent to searches. Now, a lot of people have come back to, people have told them that, say you do not consent to searches, a lawyer may tell you, or an ex-cop may tell you, or somebody else may tell you, and they come back to you and say, it didn't work. I told him I do not consent to searches, and he went ahead and searched, you see. Well, that's not why you're saying it. You're not saying it because it's a magic bullet that stops the search. You're saying it because if you consent to the search, you can't object to it later on legal grounds. Then it becomes a consent search. Then the search is legal, whatever they find is legal, and you've got nothing to argue about when it gets to court. You're not saying I don't consent to search because it stops the search. You're saying it so that it can be used legally later on. That's what you're doing it for. Is there anything else you want? No, that's it. Okay, let's move on. Let's get this thing on the road. Okay, they're going to ask you questions like that, you know. Now, let's see, where was I? Let me just start over. They're going to ask you these questions, etc., in which you are being asked to be a witness against yourself. Remember, the Fifth Amendment says you don't have to be a witness against yourself. Under conditions where what you do say can and probably will be used against you, should you be arrested and charged with a criminal offense. Needless to say, such a checkpoint detention and procedure results in a tailor-made environment to engage in a wider investigation, an opportunistic effort to find other criminal offenses or infractions of law, i.e. a fishing expedition. Okay, now, you may ask, well, this is a DUI checkpoint. They're only supposed to look at DUI, right? It's a DUI checkpoint. They can't look at anything else. That's not the way it works. Now that you're in a place where they can have plain view inspection and smell marijuana or smell alcohol or whatever, or they may see other things, or you may run off at the mouth and tell them other things for them to find, you see. Now, there's a rule, and that is don't run off at the mouth. Don't run off at the mouth. Now, the police will say, you need to answer my questions before you can leave. They can say that stuff, but it's not true under the law. They know it's not true. The lawyers know it's not true. The judges know it's not true. Apparently, the only people who don't know it's not true are the people being run through the checkpoint. You see? Well, I'm telling you now that, yes, the Supreme Court said they can run the checkpoint. Yes, you're being funneled into the checkpoint. Yes, they'll go after you if you turn around and try to escape the checkpoint. Yes, you're going to have to roll your window down. Yes, you're going to have to be frisked if that's what they want to do. But do you have to be a witness against yourself and answer all their questions? No. No. You have a right not to answer questions, not to be a witness against yourself. And we're going to get into that more later. I don't want to spend too much time on it right now, but no, you don't have to, okay? I could say more, but that appears to sum up the gist of what happens at a DUI checkpoint, okay? Now, let me interject some things here. I interject is what I wrote here, and this is something that Judge Andrew Napolitano said. And if you don't know who Judge Andrew Napolitano is, what you need to do is Google him, go to YouTube, type in Judge Andrew Napolitano, some videos will come up, and watch some of the stuff that he says, and you'll get that. He used to be a judge, I believe, in New Jersey, and now he writes books. I've got all of his books. I follow what Judge Napolitano says. I agree with him on just about everything. So there's been some rumors going around that he's not reliable because he got fired from Fox News or different things. You know, there's been rumors running around all over the place. Hey, I got news for you. The man knows the law, and we should all be thankful that there's a Judge Napolitano around to tell us things we need to hear. One of the things that's really important is there's a 5-minute video, isn't it, on YouTube, where this is the 5 minutes where he was talking that got him fired from Fox News.
Controversial things.
Yeah, look that up. Listen to that 5 minutes. Listen carefully. And then when you're done looking at it and listen carefully, listen to it again. Run it through again. And then wait a few days and listen to it again until it really sinks in, all the things he says. I'm not going to go into it now, but you need to do that. Okay? Rearrange your priorities. Make a little time to listen to Judge Napolitano. He stated that part of the constitutional rights, freedom, and liberty that we all have, that the people have, includes the right of the people to be left alone by the government. That's what he says. And go about their business and activities until such time as probable cause exists to do otherwise. Okay? Obviously, a DUI checkpoint goes against what he said. We're not being left alone. We're being funneled through a DUI checkpoint. Okay? A warrant, such as a search warrant, is a procedure which places a judge between government action, oftentimes the police, and in a criminal investigation and police effort, and the rights, freedom, and liberty of the people. So in other words, that's what a warrant is. Now, I know there's a lot of warrantless stuff going around, but the warrant is there when they say, when they go to a judge and they say, here's a affidavit or here's a sworn statement that says we have probable cause. It sets forth what the probable cause is based on. It's put before a judge, and the judge looks at it and he says, yeah, you got probable cause. I'm going to sign the warrant. He signs the warrant. You get the warrant, and then they go serve the warrant. But that's the procedure. The whole idea was to place a judge between the police coming after citizens and searching their house and seizing them of their liberty and all that stuff. A judge. So that it is a way to filter it through a judge before they just go ahead and do things. That's what it means. That's what you need to understand about how that works. All right? Warrantless criminal investigations and police activity is allowed in various instances. Yes, that's true. But at least in theory, where such a warrant is needed, and they're going ahead warrantless, and then all of a sudden you say, well, you know, you've seen it on TV. You know, the cops will come to the door, and then they'll say, where's your search warrant? You see? And they say, well, you know, that's what one case, Map versus Ohio, was about that issue. If you want to have a real entertainment, look up Map versus Ohio and read the narrative of what happened there. But anyway, they'll show you the search warrant because you have a right to see it before they come into your house and turn your house, throw your house upside down looking for something. At least in theory, they must be able to articulate why a warrant could not reasonably be obtained in a timely manner. In other words, otherwise, you know what will happen? Because that's just human nature, I guess. It's the get away with it factor. I'm going to get away with it. Yes, I need a warrant, but I got away with not getting a warrant a bunch of times, so I went ahead. I'm just going to keep doing it, you see. The thing is, the courts in the past have said to them, hey, why didn't you get a warrant? And they better be able to articulate why they didn't get one, you see. Say, well, there was a reason. The suspects were fleeing. The drugs were being flushed down the toilet, you know, or whatever, you know, whatever it is. I couldn't wait for a warrant. The fruits of the crime and the contraband was going to be gone if I did. That's one of the reasons why exigent circumstances, why the vehicle's movable. That's why there are different circumstances. You can't just, most wheels, unless it's a mobile home, you know, or a trailer, but most homes, regular homes, are not on wheels. It's going to be there a little later on, you know, when you come back, say, well, the house didn't roll down the road, so we know where the house is. That's not the same for a vehicle. All right, now, So sometimes they say that. They'll say, hey, wait a second, you should have got a warrant. There was no reason to. You could have secured the scene while the warrant was being obtained. You could have done that. And you didn't. You just went ahead like the Red Army and said, I'm going to go ahead and turn the house upside down when I could have been waiting for a warrant. Sometimes things get thrown out of court that way. You have to understand. All right. Now, I want to talk a little bit about why I believe that DUI checkpoints, even though the Supreme Court says that it doesn't violate the Fourth Amendment, I absolutely do not agree. It does violate the Fourth Amendment. The thing is, I have some reasons that I wrote down here why I believe that DUI checkpoint is a constitutional violation, and I wrote because, point one, it violates the freedom and liberty of the people to go about their business and lawful activity unhindered, and is an intrusion against their will and choice upon their right to be left alone by the government. That's point one. Point two, it does amount to a seizure called a detaining or a detainment of your freedom and liberty for a short or longer period of time without probable cause that a crime has been committed and that you committed it. Okay, so there's point two. Point three, it is an effort by the police powers of the government to compel or intimidate, and if you think there's no intimidation involved in this, then get on YouTube and watch some of these people where the recordings showed them going through a DUI checkpoint. And you will find out very quickly that it isn't this clean, homogenized, picture-perfect vision of what a DUI checkpoint is like. Just watch those videos and you'll see some intimidation. Okay? Where they could, let me start over. It is an effort by the police powers of the government to compel or intimidate you into providing verbal or other evidence against yourself, and at the same time is also a plain view opportunity for intrusion into your liberty and privacy. Now, I explained to you what plain view was, so now you understand that. By engaging in a neutral indicia investigation. Now, I say it's a neutral indicia investigation because they're funneling everybody through the checkpoint. It's an investigation on everybody, okay? Which, without the checkpoint, would very likely not or ever occur. I should say ever. I said, without those checkpoints, a lot of people would not go through this experience at all. The checkpoint is the reason they're going through this experience. 4.4, it incorrectly uses the reasonableness standard. Remember where the Supreme Court put their pry bar? On reasonableness. Okay, standard of the Fourth Amendment to engage in unreasonable intrusions of your constitutional and inherent rights, freedom, and liberty. Now, you might say to yourself, well, what's he talking about there? I know what a constitutional right is. What's an inherent right? Briefly, an inherent right is a right that you were born with, that you already had. There were rights before the U.S. Constitution. Constitution's like only 200 or so years old. You don't suppose there weren't rights before the Constitution? Of course there were. You were born with some rights. Some people call those human rights. Some people call them pre-existing rights. Justice Scalia, the late Justice Scalia of the U.S. Supreme Court, said they were pre-political rights. And he calls them pre-political, he says, because they existed before the political system. They're pre-political. Some people call them inalienable rights. In the Declaration of Independence, it says that we're endowed with certain inalienable rights. From God, of course. Now, some people who don't believe in God, they don't believe the rights came from God, then they would probably opt to go to just human rights. I have these rights by the fact that I'm a human on earth. Okay, point 5. It is a violation of the doctrine of substantive due process. I hesitate to go into the doctrine of substantive due process. I don't think I will. I don't think I need to. But it is a violation of substantive due process. I brought my Black's Law Dictionary with me, and I was going to read it to you, but I don't think so. I think that you don't really need to delve into that at this point, so we'll just move on. I could say more, but these points should be sufficient to make a case for the unconstitutionality of DUI checkpoints. Unfortunately, the Supreme Court, through Justice Rehnquist, the late Justice Rehnquist, which I have a lot of respect for Justice Rehnquist. I really do. He passed away in 2005. Justice Rehnquist, I happen to be pro-life and not pro-choice, and Justice Rehnquist submitted a dissenting opinion in Roe versus Wade, where they said that abortion was legal. Well, Justice Rehnquist wrote a very good dissenting opinion where he said no. He said it's not legal. Okay, and he was groping for some kind of reason why the court thought it could do this. There was nothing in the Constitution that said they could do such a thing. Now, this isn't a video on abortion. I have made videos on abortion, on the abortion issues, where I go into it deeply, where I go into Roe versus Wade, and you can watch that if you would like. Okay, now, what did I write after that? The High Court used the reasoning that the state has the right to address the problem of drunk driving. I agree. They have a right to address the problem of drunk driving. I would go a little farther. I'd say they've been addressing the problem of drunk driving long before there were DUI checkpoints. Okay? And that the intrusion under the freedom and liberty of the people, the intrusion upon the freedom and liberty of the people, is of a brief duration, as quick as 25 seconds in some cases. I think that's, like I said, I doubt that they last 25 seconds. And that it involved neutral indicia, meaning it was applied to everyone and does not specifically focus upon any person or persons in particular. It is therefore implied and otherwise asserted that it passes the reasonableness test. Remember the pry bar? It should be carefully noted that it is not only a matter of the time it takes to process you through the checkpoint, the amount of time one may have to be compelled to wait in line to be processed through the checkpoint, which interferes with the right of the people to their freedom and liberty and to be left alone by the government, must be factored in. Okay? Note, this logic brings in the risk of undue opportunistic flexibility of the reasonableness standard of the law, which can then be applied over and over again to encroach upon the constitutional and inherent rights, freedom, and liberty of the people. Now, let me talk about that for a second, because it's important. They're saying, well, we're going to do what's reasonable. Well, reasonableness, while there is a legal definition, I've looked it up, I've studied it, reasonableness can be somewhat vague. What's reasonable to one person is not reasonable to another. What's unreasonable to one person is not unreasonable to another. And so I'm going to go around and govern the people with a reasonableness standard. Now they're saying that funneling you through a checkpoint where all kinds of things happen, we read what could happen at a checkpoint, that's reasonable. Where are we going to go from there? The fact of the matter is, and this is the truth, you can believe me or not believe me, I suggest that you think about it and consider it. When they get something through the door, that is the first step on a stairway to something else. Say, okay, we got that one through the door, we got onto the wire with that one, we got checkpoints now. Let's take reasonableness out for a spin. Let's take it out for a spin. What else can we do by playing with the reasonableness standard? Think about that. We're going to talk about it, but I just want you to think about it. Where are we going to go from here? Is this the first rung of a ladder, or are there more rungs that we're going to climb with this? That's what you got to ask yourself. All right. As to the state having the right to address the problem of drunk driving, let it be well known and acknowledged that the police powers of the state have long been used to address the problem of drunk driving without DUI checkpoints. You see. Now, I'm going to digress a little bit here. Let me mark this off so I know where I was. Remember that business of pulling up to the DUI checkpoint? You're in line to be run through the checkpoint, and then somebody turns around and tries to get out of there and says, well, I'm not going to go through the checkpoint. I'm going to turn around. I'm going to leave. I'm sure in the beginning, before they made a law that says you couldn't do that, people were doing that. They're maybe scattering like bugs, gone. The police didn't like that. They said, hey, they're messing up our little DUI checkpoint strategy. They're scattering, you see. Well, okay. But we forgot something. You know what it is? Checkpoints aren't the only way to catch somebody for drunk driving. Let's say this happens. Let's say a car, maybe 5-10 cars back, pulls out a line and starts to go the other way. And you'll find out at these checkpoints that not only is there a checkpoint, but there's a whole line of police cars there too. You know what they're there for? To go after people getting out of line and do whatever else they need to do to back up the checkpoint effort. Okay, so the guy turns around and poof, there he goes. Police car right on him, you see. Well, now they're charging people with just leaving the line going to the thing. But why can't the police just follow? If they think it's a drunk driver, let's say, oh, that's a drunk driver, he saw it's a DUI checkpoint, he's fleeing the checkpoint because he's drunk. Well, I've been a cop. I've arrested drunk drivers. I've followed drunk drivers. I know how that works. Why don't the police just follow the car, and if the car's weaving all over the place, if the person really is drunk, make a drunk driving case the way we used to do it. What I like to call the right way. Follow the guy and stop him and put him through a sobriety check and, arrest him for being drunk out there. Why can't it work like that? Why do we have to resort to these, well, I would call it government overreach practices and procedures? Why do we have to do that? Why can't we just go after drunk drivers the way we've always done it? Why can't we? Well, the Supreme Court seems not to have considered all that. Maybe they did, and they made the wrong decision anyway. I don't know. All right, now let's keep on going here. Now, here's where I'm going to get unpopular with some people because of the things I say. But I'm going to go ahead and say them anyway because that's just the kind of guy I am. I like telling the truth, even if it hurts. Now, we should address the issue of where such checkpoints and neutral indicia practices and procedures could very well lead. By the reasoning that the High Court used, opening the door for an ever-increasing encroachment and intrusion upon the inherent and constitutional rights, freedom, and liberty of the people, we can readily envision neutral indicia stop and frisk searches. I told you, man, one rung of the ladder, hey, that worked. Let's go on the next rung. Let's go on the next rung. You see, this, you say, oh, that won't happen. Yeah, it might. Yeah, it might. We might funnel ourselves right into a police state and not know that we've done it. Okay. But anyway, let's go back. Let me read that part of it over again that I think is important. Okay. Opening the door for an ever-increasing encroachment and intrusion upon the inherent and constitutional rights, freedom, and liberty of the people, we can readily envision neutral indicia, meaning they're doing it to everybody. They're not zeroing in anybody in particular. Okay, all of a sudden they might say, hey, well, let's do neutral indicia stop and frisk searches on everybody. Neutral indicia, and maybe we'll find something. I don't doubt you will. Let's funnel people into some other kind of checkpoint and just frisk them all. Won't that work? And somebody will say, yeah, that'll work. That sounds great. Over in Michigan, they started this checkpoint, DUI checkpoint thing, and it grew from there. Now a lot of people are doing it. You think, well, that's crazy. They're not going to do anything like that. Oh, yes, they would. You know why? Because my son pointed this out. He says people are takers, and they take and take and take and take until you stop them from taking. That's just human nature, you know. I mean, it's unfortunate that I have to say these things. I'm a human too. I would like to be able, I'm a pastor. I would like to be able to say, no, people aren't going to do that. But I've been in this world a long time. I know what people do. I know what people do. So you're making a mistake if you think that's not going to happen. So one day we may have stop and frisk checkpoints where people say, okay, well, you know, we're just going to stop frisk everybody. We already did the DUI checkpoint. That worked. Let's try a stop and frisk thing. Neutral indicia style. Okay, let's go on from there. We can readily envision this kind of a thing, which the state could claim or otherwise assert and argue are necessary to maintain or secure the safety of society, which the state will say it has a right to address. And when I use the state here, I don't mean just the states. I mean the federal government can say it too. Similarly, we can envision neutral indicia, practices and procedures where, for reasons of securing necessary societal public safety, could be required to possess and show government-issued papers to the police, like we have seen in other countries. Remember, you've seen this like in Nazi Germany, in Russia, in other places, where the police just randomly go up to you and say, let me see your papers. Heaven help you if you don't have any papers. You're going to be detained until you come up with some papers. And if you have papers and they say, these papers are not in order, and you're going, they're not? The last guy had the same papers I got. His was in order, but mine aren't. You see? Well, you see, this is what we call a police state. That's not what you do in a free country. Where are your papers? And you can't just make your own papers. It has to be government-issued papers. Government approved and issued and stamped and those kind of papers. Okay? The bureaucracy of the papers. All right. You have to show this to the police one day. And they're going to say, it's you know, we're doing this to everybody. Like we have seen in other countries. In these and other situations, one can readily imagine the government using the logic and reasoning that it only amounts to a brief intrusion into the freedom and liberty of the people. Where have we heard that before? Isn't that what we heard on DUI checkpoints? Yeah, that's what we're hearing. Now, I'm saying to you, you let this slide, you say, oh yeah, well they're just going after drunk drivers. I don't care. I don't like drunk drivers either, you see. You say, well, they're just doing it to drunk drivers. Let me clue you in. When you let the government use bad laws, practices, and procedures against bad people, the next thing you know, they're using those same bad laws, practices, and procedures against everybody. If you don't believe it, then you don't understand human nature. That's what's happening. Okay? And therefore qualifies as being reasonable. Here, I heard that before too. They said it's reasonable. You want to search everybody and frisk everybody? Yeah, it's reasonable. And it's only a small intrusion. You want everybody to have papers so the police can come up behind you and say, where's your papers? Yeah, it's reasonable. It's only a slight intrusion. Sometimes the intrusion on the papers only lasts 25 seconds. Therefore, it's okay. You know, my son brought up, he says, it's not an issue of how many seconds it is. It's an issue of it not being lawful under the law of the land. That's what it's an issue of, yeah.
I would assert that precedent has already been set by the TSA example.
Yeah, the TSA is going down that road already. Yeah. However, you cannot go on the flight and walk out of the TSA inspection.
That's true.
You see. It's when they go after you for walking out, that's the problem, you see. like they're doing at DUI checkpoints, you see. My friends and brethren and fellow countrymen, and I say countrymen, I'm trying to be reasonable. It includes females, you see. There are those who don't like anything with the word man or men in it. Well, get over it. Get over it. That's all I can tell you. By that process, we can logically reason our way right into an actual or quasi-police state. An actual police state is a real police state. A quasi means it's just like a quasi-police state. We won't call it a full-blown police state, but it's just like a police state. I'm old school. I'm fairly practical and pragmatic in my methodology. Therefore, if it looks like a duck and it quacks like a duck and it waddles like a duck, it's probably a duck. That's how that works, okay? The difference is that in some countries, they don't hide the fact that it's a police state. I have more respect for that. If you go to some country, they say, well, it's a police state here, so, watch your step. Well, at least I know what I'm walking into. However, in our free country, it will be an unacknowledged police state or quasi-police state, while at the same time claiming that it is a free country where the rule of law secures the rights, freedom, and liberty of the people. Don't let them play the smoke and mirrors game or the shell game with you, where they're moving the shells all around, and they say, this is reasonable. And they say, it is? Yeah, just watch this. There you go. Which little cup is reasonable under? You see? You want them to do that? I'm almost acting like I'm a comedian, and some of this is so tragic it's funny. It's so tragic it's funny. Okay, the steps toward the incremental but steady encroachment upon the inherent rights, freedom, and liberty of the people will proceed one step at a time, each step being justified and founded upon the previous step or steps that have already occurred. It will then bear the unmistakable signs and attributes not of a free country, but of a free country governed by the consent of the people, which is what we have. What we had. We had a free country governed by the consent of the people, not living by leave of government. It will be instead a government-controlled system of existence, you see, where the government tells you what the law is. They decide what the law is. Where the government tells you, you say, how much power does the government have? It says, well, we have as much as we want. We'll tell you how much power we have. The people don't tell us anything about what our limitations are. We decide that. We will tell you what rights you have. You weren't born with any rights. These are not something, sometimes they use the word privileges instead of rights. Well, the Bill of Rights is not a Bill of Privileges. It's a Bill of Rights, you see. It should have been called not the Bill of Rights. It should have been called the Bill of Protections of Inherent Rights, which is also what the Second Amendment is. Now, I've made some videos about the Second Amendment. You have to watch those if you're interested. I would call such a progression a stairway to a government-controlled police state. Nothing I have written here should be so construed as showing that I am in favor of drunk driving or other criminal behavior or activities. I'm not in favor of drunk driving. I'm saying all these things because they need to be said, not because I want drunk drivers to drive drunk, or I want criminals to be free to engage in criminal activity and behavior without consequence. That's not what I want. All right. Terry versus Ohio. There's some cases here. I'm going to go through them real quickly. Terry versus Ohio is 392 US 1 in 1968. That is the stop and frisk case. Michigan Department of State Police versus Cites 496 US 444 is a 1990 case. That is the case that said that the checkpoints do not violate the Fourth Amendment. They used the balance test in Brown versus Texas, which the balance test is a weighing of the state's interest in preventing accidents caused by drunk driving, balanced against the level of intrusion on privacy caused by sobriety checkpoints. So they're balancing that out. And then what's in the middle of that balance? It's teeter-tottering on the fulcrum of reasonableness. That's where it's teeter-tottering. All right. Brown versus Texas. This is a 1979 case. 443 U.S. 47. Sometimes it's set forth as 443 U.S. 47, or 447, but it's actually, I believe, 47. I've seen it set forth both ways when the law schools have briefed this case. I'm not going to go into the of the case itself. It's an interesting narrative about how this case works. You can read it for yourself if you want to look it up. Just remember that it's the balance test that was used in Michigan versus Department of State Police. Now, let us go forward here.
Wait a second.
Yeah.
It is worth noting that in the case of Brown v. Texas,
yeah,
that the state of Texas had created a law saying the police can't stop and demand identification of anybody. As you were mentioning a few moments ago, about not just the stop and frisk, but the stop and demand papers. Texas already tried to do that in 1979.
Right.
The court said they couldn't.
Yeah.
Yeah. But they've already tried to do it. So this idea that they wouldn't do it, they already tried.
Yeah, they're already trying. Also, there's been an effort to, there's been scuttlebutt about an effort to create a national ID card for everybody, you see. That hasn't happened yet either, but don't think it can't happen. It sure can happen. So right now, the driver's license is the premier ID that people ask for.
Actually, you say that, but the vast majority of states now, including ours, coming up this year, will no longer accept your driver's license as for travel. You're going to have a federal ID or.
So in other words, this is a prelude to the requiring a federal ID.
Yes.
I see it on the horizon. It's probably going to happen. Yeah. And then pretty soon after that, you'll have to have papers. You see, and that's just down the road because. Like I said, people are takers. They're just going to keep on taking until the people say, enough, no more, no more. Okay, what I want to talk about here is I wrote a short treatise here called The Right to Remain Silent. I suggest that you read it. It is important. It goes into the cases of Berghaus versus Tompkins, 560 U.S. 370, 2010. Which has to do with the right to remain silent issue. I think you should read that treatise that I wrote. And it also goes into the other case of Salinas versus Texas, 133 Supreme Court, 2174, 2013. Now the Salinas case is important because the court said, You
need to mention the name of your Facebook website where they can read those.
Oh, okay. If you go to Facebook, I have Pastor Mike's Advanced Studies in Truth group. I have Pastor Mike's Investment in Truth group, and I have Investment in Truth Review Facebook page. And if you also there is my regular Facebook friend site, which is under the name Michael Michel. It's Michael without the A. That's because I was born in Europe, and they spell it that way in France and in Holland. I come from Holland. Anyway, the point is, if you Michael Benjamins, Benjamins Jr., you look that up, and it will take you to my site. Or if you just type in, Google me at just say Pastor Mike Benjamins Jr. of Oregon, it'll take you there. Go there, you can go to those sites and you can read the things that I write, and this video will be on those sites. Although I've been having trouble with Facebook, they haven't been letting me put videos on all the time, making it a little tough to put them on there. We've been putting the videos on YouTube and then linking them to Facebook and going about it that way, which is probably what we're going to do with this video.
Yeah, the YouTube if they want to see the videos on any of our videos on YouTube, it's under Investment in Truth Review.
Okay, on YouTube, it's under Investment in Truth Review. Now, I wanted to mention, I used the word investment, and that was a mistake, but now I've already got it established, and it's, like Pastor Mike's Investment in Truth group. Well, because I used the word investment, when you try to look me up, you get all these investment people pop up, you see, and I'm in with that. Had I known that was going to happen, I probably wouldn't have done it, but to change it now would be a little bit difficult since I've had it established for a while. But I wish I hadn't used the word investment. Now, what I want to talk about now is the right to remain silent at a checkpoint. You see, you have the right to remain silent at the checkpoint. Oh, by the way, I was talking about, before we got into this, I was talking about Salinas versus Texas. That's a case where the Supreme Court said that it was now possible to use the fact that you don't want to talk to the police, or that you refuse to talk to the police, that can now be used against you. You see, the reasoning was this, and it was unfortunately another giant of law, which is kind of a hero of mine, was Scalia, but he was of the opinion that if you won't answer the police questions, or you keep silent, that you're only doing so because you're guilty. You see, and that in other words, it's kind of like this "I have nothing to hide" idea. Well, of course, don't go down that road. Do not go down that road. You are well advised not to talk to the police. You're well advised not to. And it's not just me who thinks so, by the way. There's this book. It's called You Have the Right to Remain Innocent, written by James Duane, Duane. He's a professor of law at Regent College of Law. And he wrote this book, and you know what it says right at the back of the book in big letters? Don't talk to police. You see? Now, I suggest very strongly that you get this book. It cost us about, we have 2 copies, it cost us about $8 a piece to get them. And it's the best $8 that you will ever spend, because the information in this book can make a difference in your life. It is a law book, and you say, I don't want to buy a law book. I don't want to read a law book. I can't understand that anyway. Well, stop saying that. Of course you can understand. Of course you can read it and get something out of it.
That book was written for the layperson.
This book was written, exactly right. This book was written for lay people. If you want to know why you shouldn't talk to the police and why you shouldn't have this idea of I have nothing to hide, buy the book.
You are not being paid to endorse that. You're just doing it.
No, I'm not being paid to endorse this. I don't get 1 penny for telling you to buy the book. I'm telling you to buy the book because it's in your best interest. Buy the book. Don't just shine it on and say, oh yeah, Pastor Mike said we should buy. What was the name of that book? Don't talk to the police or something? I don't know. Well, heck, I'm a nice person. I'm innocent. I'm not a criminal. Why would I need that book? Because you might end up in a cage for decades if you don't. And you know what'll get you there? Running off at the mouth. Talking too much. Answering questions that some officer, you'll say, I don't want to upset the cop. He's asking me questions. How much have you had to drink? You know what your answer to that is? You don't answer the question. And I'm going to tell you how to answer the question here in a minute. But the answer to that is don't answer that question. Where did you come from? I'm not going to answer that question. Where are you going? I'm not going to answer that question. You see, apparently you are here to find out if I'm drunk. I would think that you could figure that out fairly quickly. And if I'm not drunk, am I free to leave? And if he says you're free to leave, go. Leave. Don't say, can I talk to you about something? Don't talk to him about anything. Get the heck out of there. Remember I told you? The checkpoint, if you have to be funneled through a checkpoint, and apparently you do, at some time it'll probably happen to a lot of people. In Oregon, we don't have checkpoints, but I might be in a place where they do have them. You see, someday. Don't talk to the police. You've got a constitutional right to not be a witness against yourself. Use it. Okay, we're going to get into more than that, but anyway, let me say it one more time. Don't talk to the police and buy the book. Okay? Do that. All right. So Salinas versus Texas, 133 Supreme Court, 2174, 2013. That's the case. He talks about these cases in this book. I talk about it in this treatise that I wrote. This is The Right to Remain Silent is the name of the treatise. It is done under, it was written and put out there in 2019. The number is 0028, Pastor Mike's Understanding of the Truth Issues series. Take a look at it if you haven't seen it already. Okay. We went through this. We don't need that one. We went through that enough to read the disclaimer. Now we got one piece of paper left, and then we can quit. And then you can go do whatever. In one place, you'll get different people telling you to do this different ways. But let me tell you, you don't have to talk to the police. Now, if they asked you to identify yourself, remember I said if they asked you to roll the window down, do it. If they asked you to get out of the car, do it. If they asked you to identify yourself, do it. Okay? Do that. Identify yourself. If they asked you if you have, most people have a driver's license to identify themselves. Do that. Let me tell you something else that you should do before I get into this. When you go through these checkpoints, when you are stopped by a police in just a traffic stop, have your license, your registration, and your proof of insurance in a handy place. For God's sake, don't put it in the glove compartment. Okay? In a big pile of papers, and then you're sitting there while, first of all, you're taking a chance opening the glove compartment, and then the cop is thinking, you know, what's in the glove compartment? Is there a gun in there? You see? People have been shot getting into their glove compartment. So if you're going to get into your glove compartment, if you're silly enough to have those papers in the glove compartment, tell the police officer, my registration and proof of insurance is in the glove compartment. I need to look in there. Is that going to be okay with you? You're going to feel comfortable if I do that? And he says, well, open the door, let me shine my flashlight in and make sure there's nothing but papers in there. He might say that. Let him do that. You know, if you keep your little baggie of marijuana in the glove compartment next to your papers, you're in trouble, you see. Or if you're sitting there rifling through your papers and it takes forever for you to find your papers, don't do that. Have a little cubby hole. Some people put it up on the visor. I keep mine up on the visor. Have a little cubby hole where you can easy get to what you need to get to. Have that stuff ready. The ideal situation is when the police walk up there, you've got all three things ready to go in your hand. That's the ideal situation. So you have to organize these things. You have to think of them ahead of time. Otherwise, a problem. If the cops say to you, do you mind if I look in the trunk? Yes, I don't consent to searches. What is the answer to that? Anyway, I've got you'll have different people telling you different ways to do this. This is one of the ways of things you say to police. I am asserting my right to remain silent. That's number one. Number two, I am asserting my right to counsel. I do not wish to answer questions at this or any other time. Please do not ask me any questions. If you have an attorney, then please contact my attorney and give them the name if you got one. Okay. Now, James Ramey has a different system. Ramey, yeah. J. Ramey, I should say. I got confused with James Dwayne. Okay. J. Ramey, these are the three things he says to say. He says, I do not consent to searches. I am not answering any questions and I want to speak to an attorney. I do not agree to stay here with you for any reason. Are you detaining me or am I free to go? That's what Jay Ramey says you should say. In fact, he used to send out little cards with that on a little card, and he says put it right next to your driver's license so that you have that ready to go just in case you forget what to say. While both of these have merit, I kind of wrote something different, which I think probably is better. Okay, first of all, when you're talking to the police, you should do two things. And this goes back to being professional, firm, and what did I say? Professional, firm, and business-like. Yeah. You should do this. You should say, with respect, two little words, with respect, and call the person officer. With respect, officer. So here's what I wrote that you could try. It's your choice, you could use any one of these. But anyway, this is what I wrote down. With respect, officer, I do not consent to searches. That doesn't mean they're not going to search, like I said. It just means I do not consent to it. If they find something and they violated your rights by searching in your car, for instance, where you did, if you give them consent, it's all over. If it's in plain view, it's all over. 2, on advice of counsel, I am not answering any questions. That's the Fifth Amendment. You don't have to mention the Fifth Amendment. I am not answering any questions on advice of counsel. And I want to speak to an attorney. That's your Sixth Amendment right. When you say you want to speak to an attorney, it shuts off the questioning or interrogation.
It's supposed to.
It's supposed to. It doesn't always work. You might have to repeat it.
Yeah, they will try to talk you out of it.
They'll try to talk you out of it. Don't let them talk you out of it. You see, like I said, there's some things that you have to do when you're being funneled through one of these.
And they'll play little games like, if you say, I do not consent to searches, they'll say, what do you have to hide? Don't answer that.
Don't answer that question. If they say, what do you have to hide? Do not answer that. Say, I do not answer questions. I'm not answering that question.
But bear in mind, your refusal to answer questions can now be used against you.
Can be used against you.
Your guilt.
Can be used against you. They'll want to know later on down the road, why won't you answer any questions? And that's why I added this to it. On advice of counsel, I am not answering any questions. If you buy this book and you read it, the counsel that you're doing it on advice of is James Duane. And he says, don't talk to the police. That's advice of counsel. It doesn't mean that you've got him on retainer. It doesn't mean that you've ever met him. It doesn't mean you've ever been in his office or his law school. It means that you bought his book. I told you, this is the best $8 you'll ever spend. And it's not just, I suppose you could buy the book and just read the cover and never read the book. I don't know. It's up to you. But, I would take some time and read the book. It's only about 119 pages. It's not that long. You can read it in an afternoon, depending how fast you read, Then you can say, on advice of counsel. Just think of what that puts into the mind of the police officer. Oh, you're not just being a jerk. An attorney told you not to answer these questions. By the way, James Duane points this out. You know that judges, lawyers, and police officers know, well, not all police officers know it, but most of them will not answer questions either. They tell their kids not to answer questions when the police ask questions because they all know not to do it. It's the general public doesn't know not to do it. They run off at the mouth. Don't do that, you see. So again, buy the book. So that gives the reason right there. It cuts through a lot of wondering why you're not answering questions. Are you doing it because you're guilty? No, I'm doing it because on advice of counsel. Okay. Number 3, I do not agree to stay here with you voluntarily for any reason. Which means this swirls around the idea of, am I free to leave? When is this thing over? When can I get out of this DUI checkpoint? You see? Are you detaining me, or am I free to go? You need to remember these words. You need to write this stuff down. I do not agree to to stay here with you voluntarily for any reason. Now, if you're being detained, that's not voluntary. If you say, are you detaining me or am I free to go? If the officer doesn't answer you, then you can try just leaving. If he says stop, you're being detained. Then you're not free to go. But after all, you did ask, am I free to go? If he doesn't answer, he may say, yes, you're free to go. If he says, yes, you're free to go, go. Go. Get the heck out of there. Now. Okay? If you're not sure because he won't answer, well, just start leaving. Do it slowly. Don't peel out the tires, don't do that. Do it slowly. If he has stop, well, then you're being detained. Then you know. Let's see what else I wrote here. I talked about opening the window. I talked about having your ID, registration, proof of insurance. I did that. If he or she, let's see, what did I say? Or if he says to get out of the car, then get out of the car. That's it, folks. We have addressed everything on this video. Is there anything you want to bring up?
Yes. When you do not cooperate with police, you won't answer questions, they will threaten you. They'll make threats.
They'll make threats, yeah.
They're going to threaten to do mean, terrible, and awful things. They're going to say we'll hold you. They'll say you're obstructing. They'll say they're going to arrest you.
Yep.
Let them make those threats. Stand your ground.
Stand your ground.
Yeah. Don't be rude. Don't be,
Don't get mad.
Yeah.
Don't get mad. Remember, firm, professional, and businesslike. He's testing you to see if you're going to cave. He's testing you to see if you're going to cave. Or he might try to talk you into answering questions. He might say, it's not reasonable and it's not necessary for you to not answer my questions. They may say things like this: I need you to answer my questions, and then you can go. I need you to answer my questions. That doesn't mean you have to answer them. Does he have the right to ask questions? Yes. He has the right to ask questions. At no point should you say you don't have the right to ask questions. He has the right to ask questions, he or she. But you don't have to answer to them. Why? Because the Fifth Amendment says you don't have to be a witness against yourself. Now, if you want to cut it short, 4 words will do it. I want an attorney. Those 4 words. That way there is no ambiguity about what you're saying.
Yeah, don't ask them if they think you should get an attorney.
That's correct.
Nope.
Now I'm going to read you something out of this book, just a short part of it, so that you can see what people have said, which doesn't work. I'm just going to read this little part, okay? People have said, maybe I should talk to a lawyer. In another case, they said, but excuse me, if I am right, I can have a lawyer present through all this, right? Another person said, I think I would like to talk to a lawyer. Another person said, what time will I see a lawyer? Another person said, I think I want a lawyer. Another person said, I can't afford a lawyer, but there is anyway. Can I get one? Another person said, can I call my lawyer? Another person said, I think I need a lawyer. Another person said, do you think I need a lawyer? Don't do any of these things. None of those are going to work for you. Now, it sounds in all those, somebody thinking like a normal person thinks, which nothing wrong thinking like a normal person. It probably will get you into trouble. But anyway, anybody hearing that would say, that's pretty obvious. They asked for a lawyer. They wanted a lawyer. What is the ambiguity there? Why isn't that clear? Well, the courts have said that's not clear enough. You have to say unequivocally, I want a lawyer, or I want to talk to a lawyer. Make it simple. It stops the interrogation and the questioning, usually. And if they keep questioning, just say it again. I'm not going to answer any questions because I'm doing it on advice of counsel, and I want a lawyer. I want to talk to a lawyer. Just keep repeating it. And then if they keep on playing this little game, then you say at some point, am I free to go? Am I still being detained, or am I free to go? The 25 seconds was over like 45 minutes ago, Am I free to go? And once they figure out that you're not going to cave in, I'm not sure. I can't say for sure what the police are going to do, because I have seen some fairly, well, I hate to say this, but I've seen cops that shouldn't have a gun and a badge. I've seen them. I've worked with them. I don't like working with them. I don't like people of that caliber. I'm not saying for an instant that police aren't necessary, and I'm not saying for an instant that there aren't good cops out there. There are. Some of the finest people I ever knew were cops. Okay? So if there are policemen watching this, hey, I understand. I understand. Every police department, it seems, has somebody on the department that they're not totally satisfied should have a badge and a gun. But anyway, if they see you're not going to cave in, and they see you're not going to be a witness against themselves, without saying it, it's kind of like going, I'm trying really hard to build a case against you so I can lock you in a cage, but you're not helping me. You see, why don't you be a nice person and just help me do that, and then we'll get along just famously, as I put the handcuffs on you and drag your car away to an impound lot. You see. But when they figure out you're not going to do that, because you know why? Because Jay Ramey says this. He's not your best friend. The cop is not your best friend, or she. They're not your buddies. They're not your drinking buddies. They're not your talking buddies. They're there to build cases and do police work. You're there to get the heck out of there just as soon as you can.
Yeah, if they try to stall you up with conversation about the game and stuff, don't get caught in that.
Don't get caught in that. Small talk.
Yeah.
Sometimes they get you involved in small talk so that they can get a drug sniff dog there. And it takes a little time sometimes to get the drug sniff dog there, and they'll try to stall you until the dog gets there. And Jay Ramey says, I can guarantee you when the dog gets there, he's going to cue on something. And when he cues on something, if you're still there, they're going to search. And, some people, as life goes, some people have stuff in their car that doesn't want to be found. You see? So that's the way that works. That's the way that works. When the officer has to relent and say, yeah, you're free to leave, leave and get the heck out of there, and hope that you don't have to go through that process again. Okay, is there anything else?
Yes. Whatever you do, do not lie to the police.
Yes. Okay. Good you brought that up. Do not lie to the police. It's better, if you don't answer their questions, the chances of lying to the police diminish quite a bit. You see? Don't answer their questions. Don't lie to the police. It's a separate offense in and of itself. Now, conversely, the police can lie to you all day. I used to say this to people when I was a cop. I said, if you can't help me, if you don't talk to me, I can't help you. And I heard that from other cops. They said, yeah, that's what you say. If you don't talk to me, I can't help you. I got on the phone one day and I was talking to a person, as a suspect. And I said, look, I've been investigating this case and I drew up the police report and it's going to be shipped over to the DA's office and it's going to be a real one-sided deal. That's what's going to the DA's office. Just as soon as we're done talking here, I'm filing the papers. They're going to the DA's office. Now, if you don't want this to be a one-sided issue, you better talk to me so we can have a more balanced report going to the DA. That's all gobbledygook.
It was a lie.
Yeah. Well, the one thing, I am a believer in God. I don't like to lie. I found out that to be a good cop, you have to lie.
At least that's what you were told.
At least that's what I was told. Yeah.
But
I don't like it.
No matter what you say, the police cannot, under any circumstances, use it to help you. There aren't circumstances in which they can help.
Correct.
You.
And in order to understand what he said, get the book. Get the book. I'm not going to sit here and tell you everything that's in this book. First of all, I want James Duane to be compensated for writing this book. He's like Napolitano. Thank God he wrote the book. And he needs to be compensated for writing the book. I'm not going to try to interfere with that. But I cannot emphasize enough. Get the book and read it. Get the book and read it, and when you're done reading it, you'll know why you shouldn't talk to the police. You'll know all the reason. You'll know everything you need to know about it. So, yes, the truth of the matter is this. The cops can lie to you, and they won't be in trouble, and the courts will let them get away with it.
They can say unbelievable
things. Yeah, unbelievable things. To try to build a case against you and trick you into sinking yourself. You, on the other hand, if you lie to the police, it's a criminal offense. It's a criminal offense. So don't talk to the police. Don't talk to the police. Very simple responses can be used against you. And the fact that you're innocent makes no difference. There's lots of innocent people in prison. That has been shown through DNA evidence and things like that they were innocent. And you know what put a lot of those people in prison? Talking too much. Answering police questions. There's no upside for you on answering these police questions. There's no upside. Well, I'm trying to help you. Don't fall for all these little schemes. Don't fall for it. Now, by saying all this, I'm not saying that all cops are bad. I'm not saying that at all. I'm saying what I have to say. You see, I'm just telling you the truth. And I hope that you are able to put together the value of all this from this video and other things that I do. Anything else? No? Okay, this has been Pastor Mike in Southern Oregon saying to you, it's been an honor and a privilege to be able to share all this with you. And until next time, God bless.